The family law system has changed for Aboriginal and Torres Strait Islanders children as part of changes that came into effect on the 6th of May 2024. The changes provide a simpler list of things to consider when deciding parenting arrangements. It now recognises that Aboriginal and Torres Strait Islander families may include people related by culture and not recognised as relatives under the standard legal definition of relatives. And it gives value to an Aboriginal and Torres Strait Islander child's connections with community, culture, country and language. The first consideration is safety. What arrangements would promote the safety, including safety from family violence, abuse, neglect or other harm of the child, and each person who has care of the child, whether or not the person has parental responsibility for the child. So the focus now is not just on the child, but also on the safety of the child's caregivers. A child isn't safe if they're exposed to family violence, other harm or abuse. So making sure that the family member that they're living with is okay is important as well. The next consideration is any views expressed by the child. The UN Convention on the Rights of the Child says in Article 12 that a child is capable of forming their own views, has the right to express those views freely in all matters affecting them, and to give effect to this, the opportunity to be heard either directly or through a representative or an appropriate body. In family law mediation, there's the opportunity for children to be involved either speaking to a child specialist or, if we're using a family group conference model, to be part of the mediation. The next thing to look at is the child's needs. So what are the child's developmental, psychological, emotional and cultural needs? And what is the capacity of each person with parental responsibility to provide for the child's needs? What this looks at is what's the capacity of the people with parental responsibility, so the ones who are making decisions about the children to meet the child's needs. Next is the benefit of relationships to the child. So the benefit to the child of being able to have a relationship with the child's parents and other people who are significant to the child where it's safe to do so. There may be situations where a parent doesn't have parental responsibility because they aren't able to make good decisions for the care and welfare of the child, but there is a benefit to the child of having an ongoing relationship. So that needs to be considered as well. This aspect is really looking at who are the significant relationships that the child has and are they safe people for the child. And the final general consideration is anything else that's relevant to the particular circumstances of the child. If the child is an Aboriginal or Torres Strait Islander child, the court must also consider Section 60cc, subsection 3. 3A says the child's right to enjoy the child's Aboriginal or Torres Strait Islander culture by having the support, opportunity and encouragement necessary to connect with and maintain their connection with members of their family and with their community, culture, country and language. To explore the full extent of that child's culture consistent with the child's age and developmental level and the child's views. So it's not about forcing a child to do something they don't want to do, but it's about making sure that they have the opportunity to enjoy their culture. The third part of that clause is to develop a positive appreciation for that culture. The last part of the Section 60cc looks at the likely impact of any proposed parenting order on those rights. Here's a summary of the best interest of the child factors in Section 60cc of the Family Law Act. The safety of the child and each person who has care of the child from family violence, abuse, neglect or other harm. Any views expressed by the child, the developmental, psychological, emotional and cultural needs of the child, the capacity of each person with parental responsibility to provide for the child's developmental, psychological, emotional and cultural needs, the benefits to the child of being able to have a relationship with the child's parents and other people who are significant to the child where it's safe to do so, and anything else that's relevant to the particular circumstances of the child. If the child's also an Aboriginal or Torres Strait Islander child, then it also considers the child's right to enjoy the child's Aboriginal or Torres Strait Islander culture by having the support, opportunity and encouragement necessary to connect with and maintain their connection with members of their family and with their community, culture, country and language, and to explore the full extent of that culture consistent with the child's age, developmental level and views, and to develop a positive appreciation of that culture. Thank you. The majority of people, when they separate, never go anywhere near the family court, but may use family dispute resolution to help them to sort out an arrangement for their children. So these are the factors that are also going to be considered in family dispute resolution. You may go to a mainstream service, or there may be an Aboriginal and Torres Strait Islander service available in your area. Whichever way, these are the factors that are important. If you are working with families who are separating as a professional, it would be also really valuable for you to be going through these considerations with families to help them to work out arrangements that are in the best interest of the child. If you're the relative of an Aboriginal and Torres Strait Islander child whose parental responsibility is held by someone who's not supporting their right to connect with family and culture, perhaps this is an opportunity to get some advice about what might be able to be done to help that child.